So let's get into wage and hour laws. And there are a lot of tricky areas here that I think it's very easy for small businesses, once they become employers, to make mistakes that come back to bite them a little bit later. The first one is understanding that the Fair Labor Standards Act, or sometimes you will see this abbreviated, the FLSA, that's the basic federal law of the land that says who is and is not an employee. That's the one that tells you what the federal minimum wage is. And that's the one that essentially says no one can opt out of the protections that we're giving employees. So as the name implies, it's meant to make sure that labor employees are being treated fairly. No matter what you and the employee may agree on to the contrary, the Fair Labor Standards Act will set that aside and say, nope, these are the minimum standards that we're going to have. This is the bare minimum for how you treat the people that work for you. So keep that in mind. No one can opt out of what the Fair Labor Standards Act provides for them. So regardless of what you and your employees might agree on, they can't agree to work for less than minimum wage. Or the one I hear most often, well, the employees are so happy working here and they'd rather not go out and get a second job. So they're okay with working 50, 60 hours for a bigger paycheck and not getting paid overtime. Again, they may say that today. Happy, employees that love their job, great. They may say that right now, but disgruntled, and especially disgruntled former employees, will often come back and tell a very different tale. And when they do that, if your defense is, but we agree that they wouldn't get paid overtime, the court will just laugh and say, nope, sorry, you lose. They're entitled to their overtime pay. So that's important to keep in mind. I think most small businesses are pretty familiar with minimum wage. It is currently $8.70 per hour here in Ohio. Technically, if you gross less than $319,000 in business revenue a year, you can stick to the lower federal minimum wage of $7.25. I say technically because most employers, especially right now where the economy is relatively well, are not going to be able to find the help that they need for anything less than what everyone else is already paying. So while technically, yes, you can pay a little bit less than that Ohio minimum wage, in the real world, it almost never works out. And then, of course, your tipped employees are treated a little bit differently. If any of you have employees that earn tips, as long as they earn at least $30 a month in tips, then their hourly rate can be as low as $4.35 an hour plus tips. Now, there are, of course, some exemptions to that. I think the most common one that I see with small businesses are when you have family members and it's a family-owned and operated business. For whatever reason, technically, they can be paid differently or otherwise. So this would be the situation where you bring your son into work, and you maybe you're not paying him minimum wage. You're giving him $50 for the day to help you out with something. But be very careful about trying to rely on that type of an exception when you're hiring family members, because oftentimes family members will come in and swear up and down that they were promised the sun, moon, and the stars in salary, that they didn't get paid that. Oftentimes the business owner is saying, well, I couldn't afford to pay it at the time, but I was hoping that if they helped me out, we would eventually get there. And so they'll come in, and rather than sticking their claim under the Fair Labor Standards Act, they'll say that there was a contract where they were promised that they would be paid such and such and that they didn't get it. So be very careful about trying to rely on the family labor exception. And then, of course, if anyone is hiring minors, make sure that you understand the rules in Ohio when it comes to that. So the highlights that I think small businesses should be aware of: if you're hiring anyone under 18, they need a work permit. You need to have a written agreement as to what their wages are, so that we don't get into the he said, she said of, well, I thought you were paying me $12 an hour, and you're saying, no, it's only $10 an hour. You're only 16. What are you asking for? In order to avoid all that, we want to get that written down. There are also rules around minors and breaks. So if they work more than 5 hours in a day, they're entitled to a 30-minute break. Whereas in Ohio, we don't have a law like that for adults. And then, of course, your rules around record keeping and making sure that you're keeping a list of the minors that work for you, you're keeping their time records, their break times, and that you understand how many hours that they're allowed to work, which varies, of course, depending on whether they're in school or out of school, and whether they're 14, 15, or whether they're 16, 17. And of course, keeping them out of certain dangerous jobs and occupations. So there can be a lot there with minors. Just make sure that before you start hiring minors, you sit down with your attorney, whether that's me or anyone else, and make sure you fully understand all the rules and regulations that come with that. Now, before we get into the details of overtime, I want to touch on unpaid internships, because this is a question that keeps coming up, particularly with small businesses. So we've all been there. Business is growing. We're trying to get some extra help. Internships seem like a great way to go. I can get some free labor and I can give this college kid some extra experience. Historically, I'd say probably for the last 10, 15, 20 years, you've kind of seen unpaid internships disappear. And that's because there was a lot of fighting in the courts between companies and the Department of Labor about whether or not the whole idea was even permitted. Without trying to bore everyone with the legal background and details and legalese, the Fair Labor Standards Act dictates who is and is not an employee. So just because you decide to call someone an intern doesn't necessarily mean that the government and labor agencies, labor departments will agree with that assessment. There's a legal determination there about whether or not that's the case. And so whether or not you're paying this person, again, that's a legal question. It's not just up to whatever you're hoping and whatever you want it to be. So there was a lot of tension between the Department of Labor and a lot of cases going on. It just got to a point where everybody pretty much decided that it really wasn't worth fighting to try to have unpaid interns if it was going to result in a lawsuit or a class action or some issue with the Department of Labor. And so you saw them really disappear. The cases that did stand out, the courts very much seemed to disagree with the Department of Labor. Sorry about that, everyone. I thought I'd turn that off. But the courts very much seemed to disagree with the Department of Labor. And so the Department of Labor had a set of rules that was, you could almost never fit it. There just weren't going to be unpaid interns. And the courts were leaning more towards this 7-factor primary beneficiary test that you see on your screen. And what this is looking at is, if you're going to have an unpaid intern, the question that the courts will ask is, who is the primary beneficiary? Looking at the economics of the situation, who's benefiting the most? Is it the employer or is it the intern? Now, as a small business attorney, I think that this is incredibly complicated for a small business owner to try to fit within and make sure they get it right. And I think the risk of creating a problem and ending up in an expensive litigation outweighs the benefit of ever going down this road. But you need to know what the factors are, because about a year ago, this time last year, the Department of Labor finally gave in and said, okay, here's the test. We'll go with the courts and we'll try to figure out whether or not this intern really should have been an unpaid intern or should have been treated as an employee and therefore paid at least minimum wage, overtime, et cetera, et cetera. Now, this isn't you've got to meet all 7 requirements, but we're going to look at each of these. We're going to weigh all of the facts and we're going to make a determination. Again, I think that's terrible for small businesses because it doesn't give you any set guidance. It's so fact specific that it really does come down to who's going to pay their attorneys and argue the most and the longest in court. And that's just not the situation as a small business that you want to be in, spending more money on court and attorneys than on actually whatever it is your business, your product or service is. But here are the factors. There's no expectation of compensation. And so for that reason alone, if you're going to have an unpaid intern, I think it's just not even worth offering a stipend. Because once you create that expectation of compensation, the cases very much lean towards, well, they're an employee, they were getting paid. The next factor, you've got training that's similar to an educational environment. So it really needs to be focused on what is the intern learning here, as opposed to what am I, the employer, getting out of this person's labor. Is the internship tied to an educational program? So is there coursework involved? Does the student get academic credit for the internship? Does the internship correspond to an academic calendar? So rather than just saying, I'm going to hire somebody indefinitely, or I'm going to hire somebody for the next, 7 months, it's, I'm going to have this unpaid intern for the spring semester or for the summer. So there's that tie-in back to the academic calendar. And for that same reason, we typically expect internships to be of limited duration. This next bullet point, I think, is where small businesses try to hang their hat and in a way that gets it wrong and causes problems. The internship should complement and not displace paid employees. And it needs to do that while at the same time providing educational benefits to the intern. So oftentimes a client will come in and they'll say, well, I need to hire some extra help because I'm so busy, I'm swamped, I can't do it all anymore. I think I'll get an unpaid intern rather than hiring somebody. If that is the thought process, you've almost certainly failed this test. And there's always the possibility that the intern will come back and say that they should have been paid. So if your thought process is instead of paying somebody, I'll get an unpaid intern, you're almost certainly doing it wrong. And even if you are getting an intern who's not displacing a paid employee, the focus still needs to be on what are the educational benefits that they're getting out of this internship. And then lastly, they should not be expecting and they should not be entitled to a paid position at the conclusion. Anytime you have a situation, and where we see this most often is with training, right? You bring somebody into a training role, you call it an unpaid internship, so you don't pay them for whatever period of time, and then you transition them to a paid position after the fact. That's almost always going to be regarded as you weren't paying this person as you should have been under the Fair Labor Standards Act. They're now entitled to back pay, and that will create all types of havoc. While these factors are not necessarily cut and dry, as you can see, because the question can be so blurry and so murky, it's really hard to put together an internship program that'll meet the factors and won't cause a lot of problems later on down the road. So if you do decide, I really have to, I don't see another way around it, or no, I really think our internship fits, I think there are a few things that you should keep in mind. Document, document, document. There really should be some written document between you and the intern clearly explaining that this is an unpaid internship. That document should probably also address as many of these factors as you possibly can, just to make it clear that you went through this process and you were really trying to figure out who the primary beneficiary of this internship was. You should, I think, insist that the intern be a part of an educational program, that they're getting academic credit for the internship. Again, limiting the duration, tying it into the school calendar. But the other big one, if you're going to hire an intern, don't use the traditional job ad that emphasizes what the worker has to do for your business. You know, most of us put together a job ad and you got to have these qualifications, you need this experience, you need to bring this to the table, you'll be responsible for doing all of these things. By definition, an intern doesn't have that. They're coming in to learn. It's an educational opportunity. They don't have the experience, the background, any of those criteria. And so when you use that traditional type of job ad and then you turn around and call it an internship, it really looks like you've got an employee that you just didn't want to pay. And then don't offer the intern a job at the conclusion of the internship. You've wrapped up the internship, that's great, they've learned, they've had a great experience, they've gotten their academic credit, and they move on. So that's the thing with internships. Again, I think that this is more likely to cause problems for small businesses than anything, and so I still don't think it's a good idea. I think even amongst larger companies, you're seeing that people are, for the most part, staying away from unpaid internships because of these problems. And don't fall into the mistake of thinking, well, this would never happen to me. My interns are, you know, they fit the criteria, they're getting their educational credit, it's all well and good. The other place where small businesses will mess up is that they'll have an intern, they've met the test, things are going well, but then they're, for lack of a better word, abusing the intern and asking for additional work and additional services that really aren't part of the internship, that aren't educational. Perhaps they're asking them, you know, to do custodial work, you know, take out the trash, clean the restrooms, and that's got nothing to do with the educational side of whatever the internship is. And there have been cases where even small businesses have been sued for that, and where the courts have said, okay, you need to pay them for their time doing all those other things that weren't a part of the educational internship. So again, I think it's more hassle than it's worth, and I think it's something to be careful about. Now, I will throw in a caveat before we move on. For those of you that are nonprofit organizations, this is a little bit different because the Fair Labor Standards Act recognizes that as a nonprofit, people can volunteer their time and their services to you. And so unpaid internships are treated very similarly. But again, be careful, because once you offer that unpaid intern a stipend, they start to look more like employees rather than volunteers or unpaid interns. So again, best practice, document, 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 especially for the nonprofits. For those of you that are for-profit, by and large, I would say stay away. Now, next big issue. So we've got our employees. We've figured out whether or not they're independent contractors. We've determined how to pay them. We're paying them at least minimum wage. The next big thing I see small businesses especially bump into is messing up overtime. For whatever reason, everyone likes to believe if I'm paying a salary, then you're not entitled to overtime, and that is the end of the story. Whereas if you're getting paid hourly, you are entitled to overtime. However, under the law, overtime is significantly more complicated than that. It's not just how much you're paying, which is that first part, the salary level test that we'll talk about, but you also need to meet a salary basis test and a duties test. You've got to meet all three components of this in order to get out of paying someone overtime. So just in case you're not familiar, under the Fair Labor Standards Act, if anyone works more than 40 hours in a week, they're generally entitled to overtime, which is time and a half their base pay. If you are what we call exempt from the Fair Labor Standards Act, what we really mean by exempt employee is somebody who is exempt from the overtime requirements. So when you'll see often in employee handbooks, the opposite of that, where it says non-exempt employee, that means that they are not exempt from the overtime requirements and that they are entitled to overtime. And so I know sticking non versus exempt on there can cause a lot of confusion. For whatever reason, that's the way that we attorneys have done it. I didn't make up the rules, don't shoot me. The other thing I will say before we move on and get into the specifics of the test is to be very careful about comp time. This seems to be especially popular with nonprofits. And so the idea is that everyone will work 40 hours a week. If we get really busy and we're doing great mission-driven work and you happen to work, say, 5 extra hours a week, rather than paying you overtime for those 5 additional hours, we'll comp it and you can take 5 hours of paid time off later. So you've worked 45 hours this week, you're entitled to 5 hours of overtime pay. Next week, you'll work 35 hours and take your 5 extra hours as time off. And so that it evens out, it keeps the budget nice and neat. And in theory, everyone's happy. The problem with that is that overtime is time and a half. So if you have an employee that worked that extra 5 hours a week, they're not just entitled to 5 hours off next week, they're entitled to 7.5 because it's time and a half. And so be careful with that. I see it a lot with nonprofits. And again, textbook answer is that's not right. That's not the way to do it. In the real world, as long as people are happy, these things seem to work out. As I said, once you've got a disgruntled employee or a disgruntled former employee, these things no longer work and people come back and start demanding the overtime that they were owed. So let's take a look at the salary level test. This is the part that people seem to get right most often. This is the part that I think everybody's familiar with and understands. Currently, it is $455 per week or a salary of $23,660 per year. There has in the past been talk of raising that up because that is incredibly low for 2020. Thus far, those rules haven't happened. Last I checked, they've been taken off the table, but it's one of those things that we're always keeping an eye on because if this law changes, the way you classify your employees could suddenly change overnight and you need to be prepared for that. There are some exceptions, however, to this salary level test. We'll talk a little bit later about exactly what an outside sales employee is. They're typically paid on commission, however, and so this salary level test does not apply to them. Your blue collar workers, and I've tried to find a good definition of this and it seems nearly impossible, but it's exactly what it sounds like. Your traditional blue collar worker jobs, for whatever reason, are always entitled to overtime, no matter how much they're being paid. So the most obvious example would be, if you own a factory, they're always entitled to overtime. But as a small business, I could easily see a situation where, say, you've got a mechanic shop, and it doesn't matter what you're paying the mechanics, they're blue collar workers, they're entitled to overtime. And then there's also an exception for computer employees, but that's also a very specific exception. And so we'll talk about exactly what makes someone a computer employee a little bit later on. Interestingly, as long as the computer employees are earning $27.63 per hour, they can be exempt from overtime, which if you're really quick and good with the math, that's much more than this $455 per week, which works out to $11.38 per hour. Go figure. So assuming you're paying your employee, you've got your person, we'll call him John again, they meet this salary requirement. Most small businesses stop there and say, okay, great, I don't have to pay John overtime. But as I said, there are 2 additional tests that also have to be met. So the next part of this is the salary basis test. And this is where companies will have an employee who is rightfully exempt from overtime, but because of the way that they're paying the employee, they will write themselves right out of the exemption. If you have an employee who's paid a salary and they're exempt from overtime, that salary must be fixed, predetermined, and not subject to deductions. So when that salaried employee says, hey, I've got to take off 2 hours for my doctor's appointment, you don't get to go, okay, make sure you clock out so that we can take 2 hours off of your salary this week. That's not how salary works. Now, there are some exceptions, which you see there on the screen. Absences of 1 or more days, which can be a little bit tricky. If it's personal reasons other than sickness or disability, you can certainly dock them for those days and you don't have to pay them for that. That's the textbook answer. Again, in the real world, you typically would have some sort of a paid time off policy that covers that. For those types of absences that are related to sickness or disability, again, if it's 1 or more days, you can deduct that from their salary as long as you have a bona fide leave policy in place. And so this is why these things have to go hand in hand with whatever your PTO or leave policy is. The important thing to be aware of right now is if you have somebody that, oh, they call in, or they're going to leave early, they're not feeling well after lunch, I'm going to take a half day off and go home and lay down. You can't deduct that half day from a salaried employee and still say that they're exempt from overtime. You're also allowed to make deductions for, say, disciplinary suspension. So if you've got somebody that, they're out for violating workplace rules, you've suspended them for however much time, you wouldn't have to pay them for that time. And if they're out for unpaid leave for any reason. So with small businesses, one of the big ones might be, Jessica's on salary, but she's out pregnant or she's out on a maternity leave. Then of course, as a small business, you don't have to pay her for that. So those are the ones, and this is how not just small businesses, but even larger companies will often take an employee that is rightfully exempt from overtime and then completely butcher this and write themselves out of that exemption. The third piece of it, and this is the part that I think small businesses forget the most, you're paying them enough, you're paying them correctly, you assume that's the end of the story. They also have to meet this duties test, meaning that their job duties fit into one of the following categories. Not their title, right? You don't just get to give them a fancy title, but what are they actually responsible for? So the first one is this executive professional or executive position, those executive duties. And this is the folks that they're managing the business, or they're managing a recognized division or department within the business. And they're supervising at least 2 full-time or full-time equivalent of employees. And they have the authority to hire or fire other employees, or at least have their recommendations given what is called particular weight. So it's not just they're an executive, they're supervising, but they're supervising the right number of employees. They've got a major say in the hiring and firing of those employees. And they're not just a supervisor of a handful of people, but they're a supervisor of a department or a division, or they're on the executive team. Then you have, actually, before I get to that, I should say, be careful as a business owner. Small businesses will often come in and say, hey, I can't afford to hire anybody just yet, but I want to give so-and-so, 5% of the business, and in exchange, they're going to provide services. So in theory, if, again, we'll go back to John comes in and does a knock-up job with our marketing, he's got 5% of the business in exchange for that. If he does a great job, we'll make money and John will be happy. But if things don't work out so well and the marketing, for whatever reason, doesn't take off and John doesn't get paid, John becomes disgruntled. And so you have this situation of you've got a person working for the company and you're assuming that because they're a part owner, they don't have to get paid. And so that's what you've agreed upon. What happens in reality is they turn back around to the Fair Labor Standards Act and say, no, I was working, I should have gotten paid. My 5% ownership was in addition to that. And what the law says is that if they've got a 20% or more interest in the business and they are actively involved in management, then the Fair Labor Standards Act doesn't apply. So when you've given John 5% to come in and do marketing and you don't want him to have any say in how you're running your business because it's your business, that's not good enough to get out of paying John. And so whether it's John is unhappy because he's not gotten paid, or John is unhappy just because there's been some rift or fight between the two of you that spilled over into the business, that can potentially come back to bite you. Now, administrative is another one that I see small businesses kind of assume too much and try to put too many people into this category. Your administrative duties are really those folks that are doing office work that involves some discretion and independent judgment. So your common examples would be, you hire somebody to come in and do the business's accounting on a full-time basis, right? You're hiring that chief financial officer, or you're hiring an HR professional. Those types of roles are considered administrative in the sense of these duties test, this duties test. And so assuming those other factors are met, right? They've got the duties, they're being paid the right amount, they're being paid the right way, they would be exempt from overtime. That does not include your administrative assistants, your executive assistants, your secretaries, your receptionists. Yes, it's office work, but that is not the type of discretion and independent judgment that this test is looking for. And so again, when you try to make your administrative assistant an independent contractor, or you try to say, well, I pay her a salary that's high enough, so I shouldn't have to pay overtime, that's not how it works. It's a little bit more complicated. The other duties that you sometimes come across that are exempt from overtime are going to be your learned professionals, so those folks with some sort of an advanced degree in a profession, your creative professionals, your artists, musicians, those types of positions. We talked briefly about computer employees earlier. So this is skilled work in a computer field. So think, your high-tech STEM jobs, software development, network design, those types of things. You can argue to what extent various IT type of folks fit into this. But again, we're talking about skilled work. So think more than just, and not to deride job training programs at all, but something a little bit more than, an 18-month job training program. But again, we don't tend to see, software developers with PhDs either. So somewhere in between that, you've got these computer employees that have the duties that would be exempt from overtime. And remember, they have that special rule when it comes to how much they're paid. Outside sales, we see this a lot with those businesses that are heavily driven by product sales. They need to have a sales force that grows up past the owner. And so they start to hire salespeople on commission. In order to really fit that definition under the Fair Labor Standards Act and to not create a bunch of problems, we're talking about somebody that does more than just work from home. Outside, obviously they're outside of your place of business and their job is primarily sales. But what the law actually says is that outside is away from any regular place of work. So what they're really looking for is not just, John's got a home office and so he's an outside sales rep. They're looking for John spends most of his time visiting the customers and out at the sales conventions and out doing those things, to actually meet with people and interact with them where they are and to make the sale. That's what we're looking for outside sales. So it's not enough that John sits at home and makes phone calls and sends emails. There has to be a little bit more to it than that. Now, this, of course, is a lot because there are so many different ways to meet the requirements and to meet all of the tests. There is a catch-all provision, and I don't typically see small businesses fit into this, but you should be aware there's a catch-all provision for what are called highly compensated employees. These are employees who make $100,000 or more per year, and they fit some of the requirements, but not all of them. So for example, you might have a highly compensated employee who's responsible for supervising others in the workplace, but they're not responsible for managing an entire department or managing the entire business. So they don't fully meet the executive test. But because they're highly compensated and they meet part of the executive test, they too are exempt from overtime. So again, because this is a lot of information, best practices before you decide that you've got employees that are exempt from overtime, really sit down with your attorney or your HR professional and make sure that that is in fact the case and that you're treating those employees accordingly. Now, regardless of what you decide to do with your employees, the next big issue that I think you have to be aware of is your record keeping requirements. I have talked to plaintiffs' attorneys who represent employees, particularly unhappy former employees who like to come in and file lawsuits. And no matter what the employee may think that their claim is, the plaintiff's attorney will try to talk them into shifting their claim so that it fits under the wage and hour laws. And the reason is because the burden is on you and I as the employer to prove compliance, to prove that we paid them for all of the hours that they worked, to prove that we have paid them for all of the overtime that they were entitled to. And so with small businesses in particular, the records are often a mess or non-existent. And the plaintiff's attorney knows that. And so they will be able to take advantage of that and say, well, since you can't prove it, you now need to pay it. And of course, your disgruntled former employee has told them who knows what about how many hours they supposedly worked and all the overtime that they were entitled to that they never got paid for. So obviously you want the basics in your payroll record. You want name, address, occupation, what was their rate of pay, how much did they get paid each pay period. You want a record of those hours that were worked, broken down by day and by work week. That should seem relatively obvious. How long to keep those records is a much tougher question to answer. And the reason is because it depends on which law you're looking at. Workers' comp can ask you for records going back 5 years. So somebody gets hurt on the job, that's how far back they can ask you for records for. Whereas Ohio's minimum wage law will look back 3 years. So I think at a minimum, you want to keep your records for at least 5 years from the last day that the person worked, so whatever their termination date was, but that would be the bare minimum. In addition to what you've got here on the screen, you should also be keeping your records related to your job ads, who applied for those jobs, what your hiring decision was. And you should be keeping those for at least a year, just in case somebody comes back and tries to argue, I didn't get the job because of some bad or discriminatory reason. If any of you are involved in government contracting, sometimes there will be provisions in those rules and regulations that require you to keep that information for 2 years. So just be aware of that. In addition, the longer you keep records is probably the better in this, particularly when dealing with employees. Again, textbook answer is that someone could come back and sue you for employment discrimination up to 6 years later. In the real world, I don't think we tend to see that happen very much, particularly if there's usually some sort of a negotiation about what's going on, what caused the problems. You know, there's usually a lot happening before cases end up in court. But in theory, it could be up to 6 years. And if you have a written employment agreement with any of your employees, technically the statute of limitations there is 8 years. So it could be a very long time in theory before somebody brings their claim. Again, we don't tend to see that happen very much in the real world, but it is possible. So you need to kind of set a rule for keeping these records just in case to protect you. And in addition to some of this record keeping that I often see small businesses, they just don't have, or they're not keeping, or it's in shambles. Some of the other things that you should be keeping in your personnel files are going to be whatever the application or the resume was that you used when you're making that hiring decision. Their W-4 that you had for their wage with their tax withholdings. The I-9, which shows their right to work in the United States. Your new hire reporting, where you reported your new hires to the state of Ohio. If you have an employee handbook, their signature acknowledging receipt of that handbook. Any performance reviews that you've done with this person, any corrective action plans that you might have instituted. So if nothing else, you know, make it a habit, put it on your calendar, you know, once a year, you're going through your employee files, you're making sure that all of this is there, that everything's properly documented, and you're keeping records that you need to keep.